Pose for our flag.
Allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
At this time, I'd like to announce the silence of all phones and other devices, please. And let the audience know that members may be audio or video recording by third parties during this public meeting. And the next thing is item number 13, board meeting public comment resolution number 12, 2017. That has been tabled until the next meeting on June 14th. Sunoco Logistics, Mariner 2, update, David.
Sure, thank you. First, I'd like to report on what's happening with the pending Public Utility Commission case that we brought to enforce the settlement agreement June 2015. The pleadings in that case have been closed, meaning we filed our complaint, they filed what's known as an answer in the matter, and we filed a response to that. On Monday of this week, we received something called a motion for judgment on the pleadings, and that's a legal name for a motion to basically throw out the case based on the four corners of the complaint and the answer. The response to that is due on June 12th, and there's a pre-hearing conference scheduled for July 9 in Harrisburg. So we will be responding to the motion for judgment on pleadings and attempting, and I don't think it would be very difficult, to defeat it, at which point discovery would proceed. And the pretrial conference would set up, for all intents and purposes, the schedule all the way through to a hearing. So that's what the purpose of that is. The township, as you know, has been looking to prepare effectively its own emergency response plan in the absence of any from the county or from Sunoco in the event anything were to happen on the line in West Goshen. So to that end, an RFP, request for proposal, has been sent out to 3 firms. And those proposals are due back at the end of June, with the expectation that they would be evaluated by staff and perhaps our continuing safety expert, Richard Krupowitz, with a recommendation to this board by the July meeting. And last but not least, literally the last 2 days, the Commonwealth Court has come down with 2 more decisions in the eminent domain line of cases, meaning 2 landowners challenged their right to condemn their property. That made its way up to Commonwealth Court, and on Tuesday and Wednesday, respectively, they handed down 2 decisions denying the appeals, confirming the right to eminent domain, and confirming that Sunoco is a public utility. So that's really what's happened in the last 6 weeks. Any questions from members of the board?
Thank you. Any public comments to be made?
We will begin and we will give an update, obviously, as this begins to proceed at our June 14th meeting. We've already scheduled already, since things are moving, to report to you the latest on that on the 14th. So up until then, I think that it's pretty clear that we're proceeding forward assuming what we have. Am I right, Kristen?
Yes.
Mr. Casey, you have a question?
What's the township's position regarding Sunoco while this PUC matter is going on, allowing their workers to come through the township to mark land and clear things of that nature?
I'm not familiar exactly with what they're doing, but I'm not, if you could describe it, I don't think the township
Clearing
is.
trees along the right-of-ways and
Right now, we're not bringing any action to stop them. They have the right to do that under the approvals that they received from the PUC and from DEP.
So they're allowed to come through West Goshen and perform whatever work necessary in preparation for their
They currently have all their permits and approvals to do that. In other parts of the state, they're actively laying the line.
Right, but there's a matter before the PC. Is the township moving to try to stop that from happening in some way?
We have not recommended filing any preliminary injunction in the PUC.
Yeah, and to be clear,
The township's action, the PUC, is to enforce the settlement agreement, and it's specific to the terms of where a valve station is located. The township's position is that Sunoco agreed that the valve station would be on the, what's termed as the SPLP additional use area, which is up at the pump station on Boot Road, not additional land with the Janux zone further down on Boot Road. So that's really the issue, is specific to the enforcement of where that valve station may or may not be permitted. The litigation in the PUC has nothing to do with whether or not they have the right to lay lines within existing easements or easements that they acquired through either negotiation or condemnation. So I don't want people to think that the PUC matter is trying to stop them from laying the 20-inch pipe or the 16-inch pipe. That's not the issue in litigation. And Mr. Craig reminded me that with respect to the other work in West Goshen Township, they had to acquire a stormwater management permit and an E&S permit, and they have not issued, Mr. Craig has not issued that permit yet. So that is something, until that permit is issued, they would not be doing any clearing or earth disturbance with respect to work within West Goshen. So that's being administratively reviewed by Mr. Craig, and he has requested additional information from them, and that will get issued whenever Mr. Craig says that they've met the terms of the ordinances in West Goshen. Stormwater and erosion and sedimentation control ordinances.
So, but they were out there this afternoon at that property. So I'm just curious on, does anybody know why they were out there? Oh, they were definitely out there. There was a bunch of workers up at the firehouse parked there. They had signs up there blocking the, flaggers out and everything.
Well, they're very aware that the permit hasn't been issued because they call almost daily to find out where the status of the permit is, and I tell them that Mr. Craig is working on that, and he has many other things to be working on. He's not pushing that to the front of his pile, so it will get reviewed in due course as Mr. Craig has the opportunity to do so, and they'll get the permit if and when they meet the requirements of the ordinance.
Has the township made any movement with regards to defending the zoning ordinance for township residents?
The township continues through my office to monitor your litigation and evaluates on a monthly basis whether or not to join. And at this time, we're not, I've recommended not joining.
And the two cases you mentioned at the beginning that were just decided Tuesday and Wednesday,
Yes.
did those decisions have any bearing on the township's ability to defend that ordinance? It had
Let me restate.
domain, but
I'll restate the question. Does it have any bearing on the litigation? The answer to that is absolutely. And all the Commonwealth Court did is reaffirm that they're a public utility, and if they're a public utility under the current state of the law, they have the right not only of eminent domain, but also the right to not have to follow local zoning ordinances. So yes, those cases certainly implicated any attempt to enforce the zoning ordinance.
It seems like people are ignoring the Robinson 4 case, the Supreme Court case. I'm really curious on why municipalities and lawyers in Sunoco, and why they're ignoring that very landmark decision that allows municipalities to zone the way they're allowed to do. So I'm just very curious.
I don't
Well,
think
we
are.
all have our
Mr.
interpretations.
Casey, we're not
We're not ignoring it.
You're not doing anything.
We're not ignoring.
Anybody else from the audience have anything? Okay, thank you, Mr. Berwin. There'll be no more questions tonight on Sunoco.
If you do, before David leaves, please do. If not, we'll be back with more on that on the 14th.
Reports for the month of April 2017. Please report. Tracy.
Chief Gleason, Captain Stone, and senior management of the police department are at a ceremony honoring the department tonight, so I'm giving a police report. For the month of April, we had 2,126 calls for service. There were 68 alarms, 3 were valid. There were 32 reportable accidents, and mileage for the various police cars is 22,493 miles. Selective enforcement continued for traffic on the following areas during March: Airport Road, Grove Road, Spruce Avenue, Falcon Lane, South 5 Points, North New Street, Rosary Lane, Ellis Lane, and Rosedale Avenue. Career development: the following officers did training during the month of April: ERT training, Emergency Response Team, Officer Edwards, McGee, Riley, and Story; Honor Guard training, Officer McGee; Standardized Field Sobriety Testing, Officer Grandizio; Emergency Vehicle Operations Course, Officers Cotter, Holman, Detective Maurer, Officer Boyle, Officer Graham, Sergeant Peacock, Sergeant Story; Law Enforcement Risk Management, Officer Connor, Officer Meredith; Law Enforcement Supervision, Officer Grandizio, Gilbert, Holman, Swigarelli; Group Crisis Intervention, Dispatcher Ethan Healy, and Lieutenant Domidio was at a DUI conference. Hand-to-hand countermeasures training, Officer Myers; Crisis Intervention Team Training, Officer Graham, Holman, Detective Taylor, Officer Cotter; Technical Collision Investigation, Officer Grandizio; Best Practices in Police Management, Lieutenant Domidio, Lieutenant Carroll, and Captain Stone; Missing Children, Officer Meredith; and finally, Leadership for a Lifetime, Sergeant Gracer, Sergeant Liss, Detective Sedlak, Lieutenant Carroll, Officer Gilbert, and Captain Stone. That's it for the police. Thank you.
Okay. Next is a fire marshal report. Andrea Testa.
Thank you. For the month of April, there were a total of 41 inspections: 8 commercial use and occupancy, 9 fire blocking, 12 sprinkler, 6 framing, 1 fire alarm, 2 fire extinguisher replacement, 1 kitchen hood, and 1 walkthrough. There were 5 fire calls: 2 fire alarms, 1 brush fire, 1 building fire, and 1 odor investigation. There was 1 fire call follow-up, and I attended 1 meeting. And I also helped a resident install their smoke detectors.
Thank you. And you're given the building?
Yes. All right. For the month of April, there were a total 84 building permits: 18 building, 14 electrical, 5 fire protection, 15 HVAC, 8 plumbing, 2 roofing, 7 zoning, and 7 use and occupancy. The total cost of construction was $11,734,548.35, and the total permit fees were $110,775.81. Thank you.
Thank you. Next is Board of Supervisors announcements. Phil? Is that you?
Yes. On the 20th, we had our first bicentennial function, which was the car show held back behind Iceland there. In spite of the weather and the rain in the morning, we were successful. We had a total of 84 cars on the show field, and nearly filled the parking lot. So we had a good response from a number of people in the park. So we're moving along. June 3rd is the next function, and that is at the Paoli Pike Park for East Goshen Township. And then the final will be August 6th back here in our park, and that will be a reenactment. situation, so you might come out for that. That's all I have for right now.
Thank you, Greg.
None for me.
Okay. Next is Township Manager's announcements, Casey.
Yeah, I just have one. We have an executive session tonight to discuss litigation, so May 24th, 2017. That's it. Thank you.
Bill, zoning officer.
Yes, thank you, Mr. Chairman. We are very busy with grass complaints at this time of year, several vacant properties. I've been very successful with notices of violations and the grass being cut. We haven't had to contract anyone at this time to maintain any properties as of this year. The zoning hearing board did have a hearing last month for 320 Circle Avenue. They were seeking relief for setback relief, very de minimis. Zoning hearing board did grant that relief to those residents. We do have an application that will be heard on the 19th of June at 512 Susan Drive. This will be the second time this property has had a hearing within the past 2 years. The previous owner had come in for relief for lot coverage or impervious coverage. The zoning hearing board granted them 31%. That owner did not do the work he was going to do, since sold the property to another resident who is now also going to build a garage, and he needs an additional 1%. So he's going before the zoning hearing board for a maximum of 32% impervious, and he is also seeking relief from the rear yard setback. That zoning district is a 50-foot setback from the rear. The property owner is seeking to be able to be 25 feet from the rear, simply because his neighbor, the way it would be placed, if he was to do the 50-foot as required by zoning, his neighbor would have to look at the back of his garage instead of the house. So the neighbor asked him if he would move the garage so that he could look at his house and not the back of a garage. So the property owner is going to the zoning hearing board seeking that relief to appease his neighbor. Also, where it's going to be moved to, it's a vacant piece of ground behind him, so it has no adverse effect. Would the board like to take a position on this application? Okay. The last thing I have is Mr. Milan and I had a discussion about political signs. We have a lot of signs out. We still have a lot of signs out. So we decided, actually, after last election, that we would start to, after the election was over, we would notify all the candidates to kindly remove your signs within the 15-day requirement. So that will put it at June 1st. All the candidates were sent letters, and some were hand-delivered this evening to save postage. And both political parties, the Republican Party and the Democrat Party, were also notified by mail as well. That's all I have this evening. Thank you.
On the next item, which is the approval of the minutes, I had a question, if I can. On the second page where it shows what I announced for the bicentennial, I believe I mentioned the car show also when they voted. With that minor correction, I move for approval of the minutes of the April 12th meeting.
Here a second? You? I'll second. All in favor? Aye. Yes, Margie, go on.
Hi, good evening. Unless I'm looking right past it, I don't see any reference to the approval or the amendment of the March meeting minutes. I do know Ms. Stuntebeck and I requested amendments, but I don't see any reference to whether they were going to be amended or whether they were approved with those amendments.
Yeah, I haven't brought back to the board yet. I actually had questions for Ms. Stuntebeck, so it was the election time, so I'm going to talk.
Okay, so then these minutes tonight won't be able to be approved if you approve.
No, those were about the April meeting.
So you'll amend the March?
Yeah, she had questions about the March.
Yeah, but shouldn't some reference to the March meeting minutes be in the April meeting minutes?
We can. Doesn't have to be.
Okay, and then just if you don't mind, or if you would consider maybe cutting and pasting, it's a little out of order. You state that Mr. Meekum read the following statements, but you usually go down the line, and you did that evening where Mr. Pielli announced that the meeting, he should be referenced first, and then Mr. Purnell, and then it was after Mr. Purnell discussed the car show, then that's when Mr. Halverson excused himself. And I think the order of that is important because of Mr. Meekum's, Chairman Meekum's comment about the campaign literature.
Okay, I'd have to refer to my minutes and I'll look.
I watched the video as well, and I just wanted to see where that took place, and it did take place before Mr. Okay, thank you. And then one last one, at the very end, if you kindly consider, you state that Margie Swartz stated that she is a candidate for township supervisor. Margie Swartz stated that I wanted to respond to Mr. Meekum's statement that he made earlier in the meeting, and I would like the meetings to reflect that I was actually responded to that.
Sure.
Great. And one last thing, I honestly don't remember if I provided the supervisors information on the rain tax.
I remember you showing it to them. I don't know if you actually.
Yeah. Well, it says she provided information to the supervisors on the rain tax. If you kindly delete that unless somebody has something, I don't recall handing or providing that.
Providing information can be verbal or a handout.
Correct.
So
What?
I don't know what the difference is.
I got a copy of it. You weren't.
Well, thank you for your consideration.
Thanks, Margie.
So if you're willing to consider her amendments, I think somebody has to,
I'll amend that motion to include her comments.
You got all the time? Second.
Okay, all in favor? I have it, thank you. Transfer report.
you missed number 82 on the agenda.
Yeah, I feel like
Skip over 80.
stormwater.
Oh, I'm sorry. Go ahead.
Not a lot. We're still preparing the revisions to our 15DL control plans and our pollutant reduction plan. Those are need to be completed by August 3rd so that a public comment period can begin on August 3rd. 30-day public comment period required, and then 15 days to respond to the comments after that, prior to us being able to submit them to DEP. Still no.
Is that it?
Thank you.
Mr. Peace has a question.
No questions on that?
There's a question.
Casey, you have a question?
Regarding this stormwater initiative, I'm curious why we're not discussing this stuff now. You know, the DEP has made it clear to me, three individuals from the DEP have actually, that I've spoken with, have said that they've been working with the township for years on this. We've actually expended $46,000 to have a study done. And I'm curious to know why last month we weren't discussing it. It's never been on the table, never been commented on. This month, you're talking about that October or August 3rd, which is actually August 2nd, 45 days before the 16th, it's due for a 30-day public comment period. The problem is if we don't start discussing that with the stakeholders now, and we expect people during the summer when nobody's available because they're on vacation, to then bring in stakeholders, homeowners, business owners, and the like, We are doing a disservice to the township, to to the residents and the people who own businesses here.
Since
We
the
need
plans
to-
are not complete, what would you like to discuss?
We
Well,
don't have the 218.
the plans-
permit.
First of all, the permitting information is clear as far as what's required. We have to reduce 10%.
Do you have the 2018 permit?
2018 permit won't be issued till March 18th of 2000.
No, that's when the permit is issued, but the requirements are already available since the summer of last year. So,
No, that's not correct.
no, it is
Or-
correct.
No, it's not correct.
Sure it is.
No.
I actually have a copy of them,
Yeah.
and I
it's been revised.
received, yes, it's been revised,
times, right?
they've tweaked it, but the vast majority of the information, the requirements, have always been the same.
No, they
So we need to discuss this with the public, because if we are going to consider the fee that's already been discussed publicly, the stakeholders need to know what it is they're facing. Because when I went around asking people, and they were asking me about it as a candidate, what do you know about this? And I would tell them exactly what I knew, and they were shocked by it. The DEP, Sarah Abraham, they've been preparing this for years. The DEP has been guiding this all along. Another individual from the DEP has said that they don't understand why we're not discussing this with the public now. Because how can we impose rules and figure out how we're going to have these fees that have, like I said, have already been discussed? No, they're not just two different issues. The requirements are 10% reduction over 5 years, and the only requirement is to have a plan to get to that point. There is no requirement by the DEP to charge a fee. They're not telling us what we need to do to get to that point. They're leaving it up to each individual municipality, because we here have a lot of impervious area, whereas in rural Pennsylvania, they have a lot of area that the rainwater soaks in, so their requirements are going to be different than ours. If we don't discuss this with the public, we're doing a disservice to the stakeholders. We cannot wait until August to discuss these things, because if anyone has an issue with regards to what this fee could be, or a better option, or a better idea about how to get to these numbers, that doesn't leave a whole lot of time, because the permit drop dead date is September 16th. We cannot go beyond that date. So why are we not discussing it now? If the part of the requirements is to have input from the public. That's part of the requirement. 30 days is not enough.
30 days is established by DEP, and it's difficult to discuss 3 plans that aren't done yet. So I'm not really sure what you want to discuss.
Well, is the need, we need a street sweeper. That's one on the discussion. How much do they cost? $240,000. We can easily pay for that out of our general fund surplus. Is there a fee being considered?
We haven't discussed it in 2 years because we do not have recommendations yet as to what we're going to do under the 2018 permit in order for us to qualify. So therefore, when we do, we will discuss it. And I've made it very, very clear that depending upon the funds that we need to put out in order to adhere, then we need to consider whether we do a fee or we use general fund. We have publicly said that.
No, actually,
The
no.
fee, I've said it, and the fact of the matter is that a fee distributes the entire cost among all
When did
all
you
the
discuss
non-taxables. I'm sure it was a year ago. Might have been 2 years ago. Might have been 2 years ago. Because at that point, we were considering a stormwater authority, and then the legislation changed.
Right.
And I even think that I've said publicly that since it has changed, we as a second-class municipality do not need a stormwater authority to establish a fix. But we do not know until we're provided from what we have to do to adhere to at least a 5-year plan as to whether we go general fund or we go fee, which would distribute the cost between residents and all the non-taxables. Let's face it, 8 high schools and the university is a lot of impervious surface.
Yes.
So why would we as residents just pay that bill? So therefore, with the fee, you distribute it to all of the users. But we have waited in order to do it until we hear exactly what our program for our 5, it is at least minimum 5, 10, or is it 10 years?
It's 5 years.
5.
That's not completely correct. It's
It's-
5,
Mr. Casey, would you like to respond?
Can we answer?
Sure.
it's 5 years for the PRP, 15 years for the TMDL control plans.
We have to reduce TMDL 10% in 5
No.
years.
67%.
Because the requirements online say 10% over 5
Only
years.
for the PRPs, TMDLs, you're totally different.
Okay. So for 15 years, so that was the $4 million 15 to 20 year
For the
thing
two
that was
TMDL
discussed.
plans, that's the original cost
Right.
estimate, $4 million.
So we do have an estimate, and
For the
we can
TMDL
figure this
plans
out.
only, yes.
Right.
And that's
So,
now being revised, so that estimate is no longer valid.
so
We're waiting.
we're waiting on, see, that's the part I don't understand. We already know what the requirements are because they're at the DEP's
We don't know
website.
until we get the permit.
We have to propose to the DEP how to meet those requirements.
Exactly.
And that's the purpose of the preparation of the PRP and TMDL plans.
And
How
when we
to
know,
meet
we'll
those
know.
requirements. And then DEP has to review them and tell us whether that's acceptable. And then we can set a budget.
And then we'll get a permit.
Right. But who's preparing the plan?
HRG.
HRG. And so we've expended the money on that.
No, some of it we've expended, not all of it. They're still in preparation.
But don't you think it would be a good idea to discuss this publicly at every single meeting leading up until August so that then people can have the opportunity to have an educated comment to make? Don't you think that would be better than denying that it's ever been discussed?
I
I
don't know
don't
what you
think
want to
anybody's
discuss.
denied it's been discussed. We don't have a plan to present yet.
So I'm not going to get one with my right to know
No, you're
request.
not going to get a plan. In
We
fact,
don't have one.
I got an email today, in fact, from HRG saying that, please make it clear to Mr. Casey, there is no plan. There's studies, there are analyses, there are projections, but there's no approved plan that you think is out there. They're working as a consultant to provide recommendations for how the township will meet the permit obligations. There's no final document that's been approved. It's been a work in progress, it's been going on for at least 2 years.
That's one,
Longer
yeah.
than 4 years.
Yeah, it's at least 4 years.
Any further? I would move for approval of the treasurer's report to be dated April 30, 17 for the general fund, state fund, the waste and recycling fund, capital reserve fund, and the bills to be paid therefrom.
I'll second that.
Hi again. On April 12th, looks like we expended $409,894 for insurance. Is that property insurance or health insurance or?
I believe G, our annual property insurance to select.
And it's listed under a contractual expense, so I'm curious when that contract was signed.
That's the line that it's on, we're under no contract with anyone.
Have we ever bid our property insurance out recently?
We do it every year, absolutely. 2 or 3 issuers in the country that do municipal work anymore, so we're very limited.
I see that our insurance covers 838 Lincoln Avenue, a storage garage. That's just a property that I was unaware that the township owned.
Yeah, that's the old one. Yeah, we'll have to have that removed. Yes.
Well, I actually found this information in the bond information that you're approving tonight or discussing tonight. So, I mean, it's apparent that 838 Lincoln Avenue is a property that's on our insurance plan, and you're saying we don't own that property?
We rented it for many years and we'll have to have it removed.
Okay. So are we paying somebody else's insurance, property insurance?
We have a blanket coverage for all of our property.
Okay.
It's just a matter of notifying the insurance company that that property is no longer being possessed by the township.
Yes. Okay. Okay, I think that's all. Thank you.
Motion second. Anybody else? Questions? Comments? Okay, we're good.
Second motion.
Okay.
Very good, second. Good, second.
All in favor? Aye. Ayes have it. Okay. Astoria project discussion and proposed zoning amendment. Kristen?
Mr. Kodracker is here representing the applicant, so he can explain to the board what he's seeking.
Good evening, board members. Thank you. I'll be brief tonight. I see a bit of a full house here. I'm Lou Colagreco, representing Astoria Property Company. Catherine, you want to come up here? Catherine Singleton of Astoria, and Tim Gephardt of Move Health. Very brief presentation. What we have put before the township and what you'll be having a public hearing on in June is a proposal to allow for an ambulatory care center to be situated within the I-1 zoning district. Astoria is the equitable owner of property situated at 1229 and 1230 American Boulevard in Westchester. And right now, this type of facility is not a permitted use. They have the property under agreement. We've proposed adding this as a permitted use to this zoning district. I think this is back near the helicopter museum don't think I know, it's back near the helicopter museum. It's an existing office building, nice building. I think we might even have a picture of it, Rick, if we have it on the slideshow. And Tim can explain to you what the medical services will be in the facility. Your ordinance already provides for ambulatory care centers. The one difference with this center is that it has an overnight component to it, and we're proposing an overnight component for reasons that Tim can explain, not to exceed 72 hours. As I said, we filed the application to amend the ordinance a few weeks ago. The Planning Commission unanimously last night recommended that this board adopt the ordinance amendment. So there's the location. I can't tell from these roofs what our building is. That looks like our roof. So that's the building in question. That's the district in question. That's the area in question. Tim, why don't you briefly explain what the services would be in this facility?
Good evening. As Lou mentioned, we're an ambulatory surgery center. We hyper-focus on total joint replacement. So our focus is on hip and knee replacements. Again, these are an ambulatory patient group, so they do qualify to go home. But we choose to keep them for up to a 72-hour, typically for 24 to 48-hour period for education and then physical therapy as part of our program. So we are highly selective in who we bring into the program to make sure that these patients are self-preserving, that they're right for the setting and not for a more acute setting. And we are highly prescriptive with our program throughout. So we have a very regimented program that starts actually before the surgery, continues through the surgery, for their stay within our facility, and actually post-operatively for up to 90 days. So we are trying to make sure that we give our patients the very best care that we can get.
So this basically provides patients overnight hospital accommodations where they could not get it elsewhere?
So actually, our accommodations are non-hospital, so these are, again, patients that would be eligible to go home to their residence.
Hospital as a
As a general.
So this provides overnight accommodations
Yes.
where my patients not be able to have. Is that what you're
Correct,
saying?
yes, correct.
Can you explain, I know we had a staff meeting and you explained how limited in terms of the number of patients that ever be here at one time and why your philosophy is that they're benefited by staying because of the rehabilitative services that they're getting in that 72 hours. I think that's important for the board to hear.
Yeah, absolutely. So we are very, very hyper-focused and again, very small in scale. So this is a picture of one of our facilities in Texas. We actually have 6 rooms that we have our patients stay overnight. So at no time would we have more than 6 patients within the program. We run a couple days a week again, so at any given time we have 6 patients plus our staff to support those patients. And so we have a very small scale.
It wasn't part of it, Hugger, you can jump in, but the way I understood it was that people are having knees replaced or hips replaced. If they're going home, they're not necessarily getting rehabilitative care and help they need to get up and moving. And that if they're able to stay in overnight lodging at this facility, they have the caregivers, the physical therapists, the nurses, the doctors, whatever, that can make sure they're getting onto their feet and moving their joints that they've just been replaced. And that tends to help them in the long run in terms of making sure that the joint stays.
No, that's correct. The whole purpose here is, as Tim suggested, was it's a small surgical center, and then provide facilities where, Ray, as you put it, patients can convalesce quicker than they ordinarily might at home, and not have to come back and forth to different specialists the next day, or get this checked out, or get that checked out. It's only a 72-hour limit. Do we have the suites? Do we have a slide of what the suites look like? So that's what the rehab suites look like.
Is there provision there for the caregiver or the spouse, whatever, to stay with the patient?
Yes, so we actually encourage our support persons, what we call them, to stay within the room. Actually, in the back of the room there, it's a sofa sleeper. We've actually found that a lot of the significant others, especially spouses, do actually stay in the bed with their significant others. So we highly encourage a support person to be there with their.
So they become part of the instruction regimen?
Absolutely. So we highly encourage that person, because when they do transition back to the home, we want them to have somebody that's also educated in their care pathway to know what's the best care for them to get at home, and then with their physical therapy that they'll have continuing through that 90-day period.
And my notes reflect that you have these operations 2 days a week, 6 patients per day, and then on the other days you have smaller, like 12 to 15 cases of smaller procedures like carpal tunnel.
Correct. Yeah, we would have orthopedic procedures on those days, but again, a smaller scale.
So obviously this isn't the official hearing on the application, but since we wanted to give the board a heads up, so if there's any questions, and we won't take any more of your time, if there's any questions you'd like to hear specifically addressed when we come back in June at the hearing, just go to Casey and he'll forward them to me. We'll make sure we have answers for any questions that the township might have on this proposed amendment.
The way the ordinance was drafted by the applicant was that it's in the I-1 district as a by right use, and one of the comments that the ordinance was sent to the County Planning Commission, they had suggested or thought, to say to the board, would you prefer that this be something that is allowed by conditional use? Given the nature of this use and the limited number of people that would be allowed to stay, it was staff's recommendation that it be a by right use. It's the I-1 district, but that obviously is a policy decision. If the board felt that there was some additional protections you needed to put into the ordinance, then that might be something you would do by conditional use, but I think staff felt comfortable that it could be done as a by right use.
Yeah, we're not covered at the present time with this, correct?
It's not allowed at all in the I-1 district right now. But given that it is the I-1 district, and given the definitions are pretty specific as to what the use can be, I think we felt, as I said, comfortable using it as by right, not requiring conditional use.
Yeah, there's a need for 72-hour care when they don't have hospital opportunity.
Right.
Yes, I'm fine.
Any questions? Okay. Anybody from the audience? Yes, Bob.
If you can just repeat this, I'm aware. What
You're doing invasive procedures there, correct?
Yeah, so they would be considered joint replacements.
Yeah,
so,
it's
yes.
invasive. Yeah, okay. What's the difference between an outpatient surgical unit and an ambulatory care unit?
They're very similar. I know your township has specific zoning purposes, and maybe so speak a little bit more about
The only provision, I'm not so sure about the outpatient surgical use that you just talked about, but the only change I noted that we needed to make or asked to be made in the ambulatory care center was that it specifically precluded the overnight stay. And the way these places have evolved, I think that this definition was probably written, I don't know when it was written, but it was obvious, yeah, it was not written with today's medicine and today's treatment procedures in mind. So that's what we're asking the township to consider, that this be not only the current ordinance definition makes you come in and out the same day. It would not allow for this type of use.
Correct.
So that's really the gist of what we're asking the township to consider.
It still isn't really, it's an outpatient surgical unit, basically.
Yeah, essentially,
The
that's
second question is because I'm not for Pennsylvania law,
Mhm.
but does this require a COA?
No, it does not.
Yeah, so just to further answer your question, the zoning ordinance today has a definition for ambulatory care center, which they can meet, except for the provision that the ambulatory care center in today's ordinance says there can be no overnight stay. So the only thing that they're proposing is to add a sentence to the end of the definition that allows for temporary lodging for the patients for up to 72 hours. So that's the only change they're making to the definition, and then they're allowing it in the island district.
Thank you. Duration per stay not exceeding 72 hours.
There was a neighbor who went to a place, I think it was around Oaks. It was either a knee or a hip, and he was 24 or 48 hours. Are you familiar with that place?
the place in Oaks.
I'm not familiar with it, but this model is more popular.
Okay. Because I know he was very pleased with the results of his.
Move is headquartered out of Colorado, right?
Yeah, Denver, Colorado.
Out of Denver, Colorado. The site you're looking at there, the suite you're looking at is from Texas,
Yes, and then the greater Austin area.
in Austin, and I think you're going to see more of these. I mean, that's, what do I know, but it seems like it's the way of the future.
Way to go.
Yeah.
And Mr. Calgar, if the applicant is successful in getting the zoning amendment, would they be purchasing the property?
Yes.
Any other questions from the audience?
I was
Lady?
just,
You might come up here, please.
curious.
You have to come out because it's being videotaped. Not videotaped,
I just have a question that's really, I guess, more curiosity than anything. I'm sure that you have feasibility studies done for the establishment of this
Yes.
place.
Yes.
And I'm sure you're aware that there are a number of hospitals and the Rothman Institute as well. And I think that's probably what you were referring to, Mr. Meacham. And they do a very similar model. I had a hip replacement. I was out in 24 hours, went home, no physical therapy, nothing. So
This
I
would have
think you
helped
have
you.
to talk about that.
This sort of helps.
This model would have helped you quite a bit.
Why?
This one for those who might want additional time.
Yes.
Not everybody does,
Right,
but there are those who need it.
So yeah, we feel that our model allows our patients to become better educated on their post-care needs and their medication, physical therapy, what the continued care process is going to be for them to get fully back to their full time.
Could I have your name, ma'am?
Oh. Roberta Lewis.
Louis, very good.
Second word? Oh.
Yes, Doug.
Good evening, Dr. White of West Goshen. I was at the Planning Commission meeting last night, and I think this is a very good plan, and I urge its approval. And I see no problem with the location. It's a good location.
We're not approving the work, we're just making recommendations to go forward with definitions for their next presentation.
Do that.
Yeah, so the actual motion that the board would want would be to authorize advertising for a public hearing on June 14th as part of your regularly scheduled 7 p.m. meeting.
Anybody else?
Okay, I'm sorry.
I just have one simple question. Who's responsible for oversight for the zoning for the 72 hours? Is it the facility or the township?
Township.
Zoning officer is
Zoning
always
officer is
responsible
always
for
responsible.
enforcement.
But how?
Same way any zoning enforcement is done, with complaints being lodged that they're not adhering to the terms of the ordinance.
Is the concern that a patient would actually stay longer than the 72 hours, and how would the township ensure that we were meeting that? I see. The program.
Well, who's eating that cost?
Well, the program is designed for a very specific population of people who are younger and very healthy. Most people, depending on a person's health, is the best place for them to have this procedure. To the gentleman's earlier question about, is a hospital the right place? Is an outpatient center the right place? It really depends on the patient. So the only patients that will be having surgeries in the center are healthy people who are not ill. And by keeping them in the center, they're not exposed to infections and the other things that can happen in a hospital. So if we had a patient who needed to stay longer than 72 hours, they wouldn't meet our criteria in the beginning, and they would be transferred to a hospital at that point. Tim, is that correct? So we will have a transfer agreement with a hospital. The program, as Tim has described, is very prescribed and specific. So we'll be policing ourselves only to the extent that we don't want patients there longer than 48 hours. I know that doesn't address the policing of it, but that's how operationally the program is designed.
Thank you.
This is fast. Who licenses your facility?
So our, so the state of Pennsylvania Department of Health, so the surgery center is licensed through that facility, through that department.
Okay, we got a motion.
Oh, I'm sorry.
Second.
All in favor? Aye. Ayes have it. Good, thanks.
Thank you. That's your time.
Good, thank you. Next is discussion and possible approval of final land development plan for 2,543 square foot wholesale sales building at 806 East Market Street.
This is a small piece of ground off of East Market Street at Wilson Avenue. The existing use is 100% impervious and is an auto storage lot. The proposed use is to add back 20% green areas required by the code. The existing use is pre-existing nonconformity. To construct a small building here and parking here to allow for preparation of new vehicles for sale from a Kia dealer on Westtown Road. The vehicles would be shuttled over one at a time. There would be no deliveries by tractor trailers or any other large trucks. So nothing on Wilson Avenue or East Market Street. They'd be prepped for delivery and then returned to Kia on Westtown Road. Stormwater requirements are met by the removal of 20% of the impervious surface back to grass. So there's no other stormwater facilities needed. It is a significant improvement over what's there now. And those are the only facilities on the site. And the Planning Commission has reviewed it and recommended it for approval.
And the board is familiar with this because of the conditional use application, if you recall. And some of those restrictions that Mr. Craig was just mentioning are all conditions of the conditional use approval, so they're tied to the zoning.
Yeah, they appeared before us. It used to be the Honda shop.
I'll make the motion to be approved.
Yeah, I'd like it second.
Second.
Anything from the public?
Especially get more green space.
Yeah, exactly.
Hearing nothing? All in favor?
Aye.
Aye. Ayes have it. Thank you. Next, discussion and possible approval of West Goshen Sewer Authority lease termination agreement, resolution 11 of 2017. Ben?
Good evening. My name is Ben Reed. I'm a municipal finance attorney, Rosen Simon, LLP in Harrisburg. We're bond counsel to West Goshen Sewer Authority. So I'm here to present the resolutions of the resolution of the township. But if I may, I can take a step back and update you on what's occurred since the township took action on the guarantee ordinance. I don't have the date in front of me, I don't have the ordinance, but a couple months ago I was here to present a guarantee ordinance of the township, and that ordinance was enacted that approved a guarantee agreement. We prepared paperwork that was signed and submitted to the Department of Community and Economic Development to have those proceedings approved, to have the township's, the township guarantee approved. We secured that approval. The transaction has progressed. On May 12th, the authority meeting, was it May 11th or May 12th? May 11th, the authority adopted what's considered a parameters bond resolution, which authorized all steps of the authority to issue a new series of bonds in the same not to exceed amount of $27 million. That resolution authorized the authority to enter into a parameters bond purchase agreement with RBC Capital Markets, and it also set forth the structure under which RBC would market and sell those bonds. That agreement was entered into, and the resolution also authorized the signature for an addendum to the bond purchase agreement at such time as it was deemed prudent to market and sell the bonds. So it authorized the chairman or the vice chairman of the authority board to, so to speak, give the green light to RBC to ultimately sell the bonds. Now, at least for a week to 10 days, if not 2 weeks, the target date for selling the bonds was May 23rd. So the build-up to that included the dissemination of a preliminary official statement, like an offering document to show potential investors background on the authority and the township. So that was posted, has to be posted at least a week before bonds are sold, and they satisfied that. That preliminary official statement was posted. The bonds were sold by RBC Capital Markets yesterday, and essentially, they identify potential investors. I'm not counsel to RBC, so I don't know all the inner workings of the process, but by late morning or early afternoon yesterday, they had reached agreements to sell the bonds, each maturity going out to 2037. They sold those bonds, and at that time, they released the form of an addendum to the bond purchase agreement, which showed the numbers of the transaction, the amount of bonds that will be issued on June 27th, which is the closing date of the loan. So we reviewed those numbers. We looked at the maximum guarantee of the township that was authorized to make sure that these bonds were sold within the parameters of the guarantee ordinance, which was issued in a not to exceed amount of $27 million. So these new bonds, or the bonds that were sold yesterday, were sold at a par amount, or the amount of principal, the principal amount of the bonds that will be outstanding to the authority in the amount of $17,055,000. So we were within the parameters of the guarantee ordinance, so we complied with that. The guarantee ordinance of the township authorized a number of steps, and one of them is it allows, or it authorizes the township to do other necessary steps in connection with its guarantee and authorizes the signature of documents. At that time, and it's common that it's not always known the exact steps that will be needed. Underwriters change their requirements, their internal mechanisms will say, well, we're going to need a a certain document for this transaction. You don't know it all when you have initial authorization, so we have this blanket authorization of the township. The bond purchase agreement required by RBC required a joinder to the bond purchase agreement, which is a township document, which essentially certifies that the representations and warranties specifically, or more specifically to the financial information that was posted in the preliminary official statement, to certify that those are correct, and if there's going to be any material adverse changes, the township would give notice. That document was reviewed by your solicitors. We had that document pre-signed and held in escrow until yesterday when the bonds were priced. Just to clarify or to ratify that action or the approval of that, we built into the resolution that I'm going to present tonight ratification of the signing of that joiner to the bond purchase agreement. So that's a, well, maybe not so brief overview of the steps that have led up to today. And the authority wanted me to give that recap, and they also wanted me to, to clarify, at least from our perspective, that there haven't been irregularities in this process. This is, from my perspective, the action taken and the steps taken are very consistent with what I would see in most transactions that I do. The parameters approach is a very common approach. In fact, the authorizing the steps needed to close the bond issue and to take future action has become a more commonplace approach than waiting until the day the bonds are priced to have the authority meet and approve the final numbers. It delegated that authority to the chairman. So those steps were taken. We plan to give notice to the Delaware Valley Regional Finance Authority, a 30-day notice to pay off the 1998 bond of the authority on June 27th. So that's where we are today. Do you have any questions before I get into the actual action that we're asking you to take tonight?
So the actual bond sale was 17 million?
17,055,000. That's the amount of principal amount of bonds that the authority will be responsible for paying, and that's the amount. And as we get into the documents a little more, that's the amount of bonds and debt service of which will be the responsibility under the lease agreement with the township to make through the revenue that's generated and collected to make those payments to the authority so they can make the debt service payments on those bonds.
Thank you.
What would be our effective rate?
Yeah, this is, you're hearing a lot of this information before the full authority board has. And this is normally a presentation that at least this aspect is what RBC would give. You said the effective rate, I think a key figure is the yield or the effective rate of the bonds. Looks like it's 2.9125%.
Thank you.
You're welcome.
You can tell your account here.
Wow.
Get to the bottom line real quick.
Right.
So before us, the resolution number 11.
Resolution number 11. This resolution authorizes entering into a lease termination agreement. As you know, there's a current lease out there. In order to enter into a new lease, you need to terminate the existing lease. So this resolution authorizes entering into a lease termination agreement, which was made available to the supervisors. I'm happy to hand out any copies if you'd like. It's the substantial form of the lease termination agreement. It's a very simple document reviewed by your solicitors. It's important to note that the resolution authorizes entering into these agreements, entering into the lease termination agreement on the date of closing. So the closing date of the bonds were sold yesterday. It was, the prices were locked in, and there's a commitment to close the bond issue, which is set for June 27th. So I don't anticipate any changes to the lease termination agreement between now and then. It's in a form that's been reviewed by your solicitors. On that date, the existing lease will be terminated, and a new lease will be entered into, and this resolution also authorizes the substantial form of the new lease, which has been circulated for review. Your several weeks, if not months, and it's been reviewed by your solicitor. We've incorporated the comments that they provided. Again, there remains the possibility that there could be some minor adjustments to the lease pursuant to negotiations, nothing unilateral, but the final form of the lease will be signed and entered into on June 27th.
Just jump in. Steve McGuire in my office handles almost all the bond transactions that our municipal clients are involved in, so he's really done most of the work on this. Amanda Sundquist is here. She works with Ross Unruh as the authority solicitor. They have also weighed in on the lease, obviously. Mr. McGuire met with Casey Lalonde and Mike Maffa to make sure that they were comfortable with the way the lease is drafted. Mr. McGuire indicated to me today that the lease is virtually identical to the lease you have now. There's not really anything changing with respect to how the relationship is between the authority and the township. So Mr. Reed is correct that our office has worked cooperatively with the authority solicitor and your staff and is comfortable with the lease terms.
And finally, with the resolution, as I just discussed, it ratifies entering into the limited joinder to the bond purchase agreement, which was finalized yesterday. Actually, it was submitted to RBC Capital Markets, which allowed this transaction to price yesterday.
So in short, Resolution 11 is termination of the old lease, the new lease and the joinder.
That's correct.
I have no questions. I mean, you're on the authority. So,
Do you have anything?
No, I agree with everything you just said.
Any questions from the audience?
Were there two separate resolutions, or that was all one?
There's one, and on the agenda,
Just for clarification, there's a license agreement, so I will cover that after this resolution is dealt with, because that deals with the authority on the authority property. There's also a firing range that's used by the police department, and it was recommended that the sewer area be separated out from the firing range property. So we have proposed a license agreement with respect to the firing range, and that will be a separate, not covered by this resolution.
that's more of a housekeeping for the property down there. But
Yeah,
the actual
well-
warranty, there's one resolution, which resolution is lease termination, the new lease, and the joinder.
Okay. Comments, questions are going to be all over the place a little bit. Initially, I believe, back maybe in October, when RBC first presented their bond pitch to the authority, there was discussion about offering first priority to West Goshen residents to purchase the bonds through a retail sale. There are many residents that do like to invest in their community. Sounds like we missed out on that, so it's kind of disappointing that that wasn't investigated further.
Yeah, I don't think the authority ever, the chairman's here, I don't think the authority ever took official action on doing that, so, at the time, so.
So,
It can still be available in the secondary market.
yeah, but we pay a premium to get that, so. Can someone just confirm whether or not we will be incurring any type of fee for refunding that outstanding loan with Del Val?
I don't believe so.
I don't
There was,
believe there's a prepayment.
there was never a prepayment penalty, no, absolutely.
I just know the last refunding we did in 2013 on the township side, we incurred like a $245,000 termination fee that.
No, that's not the case here.
Okay. Who is the sinking fund depository? Who will we be depositing? They're trustees, right? Is that separate than a sinking fund?
The sinking fund concept is debt act, the local government debt act concept about who the township makes payments to, it has to honor and guarantee. Here, the trustee sinking fund depository for paying it in the same entity, which is full effect.
Who did the township rely on for financial advice in entering this agreement?
Well, it's the authority's lending, so.
But we're backing it, so we're ultimately responsible for $17 million. So did we get financial advice from anyone before entering and signing into this agreement this evening?
Personally?
Does this make financial sense for the township to enter into this $17 million debt? This lease that we're signing tonight requires us, we're backing $17 million. So does this, what does our director of finance?
Backing in full faith the authority.
Right. We didn't seek financial advice. They did, but the township did not. Okay. I know it was discussed, level debt service, payback level debt over the next so many years. I think it was going to be like, I don't know, 12 or 15, well, 1.2 or 1.5 million dollars a year that would be responsible.
Substantially low debt service.
Okay. Why I asked is on the information that I received yesterday, page 16, West Goshen Sewer Authority summary. It shows principal maturity or mandatory sinking fund payment for fiscal year. It starts out in 2018 at $850,000, and then in 2037, $2,040,000. Doesn't appear very debt.
I don't see what you're referring to. That's the, this appears to be the maximum debt service schedule. That's not the final schedule.
And who signed our agreement yesterday? The jointer?
The chairman of the board of supervisors.
I just know in the past when we've entered into these agreements, it was brought before the board in a public meeting, who would be the signatory.
That's the chairman.
That's not voted, something voted on?
Chairman and or vice chairman, quite legal.
Yeah, and I think Mr. Reed explained that the ordinance that was adopted authorized whatever necessary actions, whatever is a little bit broad, but necessary, if there were additional documentation that needed to be signed to support the guarantee, the ordinance authorized that. So this is sort of a belt and suspenders.
On the joinder, I'll just read this and move on to my next comments, but as you know, I've questioned the budget, specifically 2016, in the past, and I'm not very comfortable as a resident because I still seem to think there's $2 million that's unaccounted for or didn't go where it was, we were told it was going to go for. But the joinder just does say the official statement does not and will not contain any untrue statement of a material fact or omit to state any material fact required to be stated therein or necessary to make the statements therein. So I'm just comfortable as a citizen wanting to know and be presented with a more transparent budgeting process and budget in general, that I don't feel comfortable with the board signing this tonight. I did get a copy of the credit report, the S&P credit report at the May 11th or 12th Sewer Authority meeting. I had someone else who's a little more knowledgeable and thorough in such matters look at that report, and just I'm going to read off some comments that he made regarding the S&P report. Excuse me. Page 2, the summary says weak debt and contingent liability position. And that's in quotes, that's what the report said. His comments were weak infers not good. You would think it should say strong. Page 3 of the report says, in quotes, indicating financial practices exist in most areas, but governance officials might not monitor them on a regular basis. These comments, to me, this indicates a lack of oversight by the township manager and the board of supervisors. I've brought this matter to the board in the past. I've asked about 5-year capital improvement plans. Page 3 of the S&P report says 5-year financial plan is not shared with the board on a regular basis. And let's see, yellow parentheses, looks like they sent $2 million over to the sewer authority with a question mark. Again, there's that $2 million figure. The township historically gets a windfall from something. QVC execs selling options or increased revenue from building permit revenue. Counting on serendipity for revenue that you cannot foresee is not good business practice. And then also page 3, it says very strong budgetary flexibility, but 2016 sounds like it was not a good year. Okay, and then finally maybe OPEB benefits, short for other post-employment benefits, right? We have a $5.3 million liability. That's not insignificant. He did say, I do not know anyone who funds these in advance. It could be an issue. The term post-employment makes me wonder what we are funding that is worth $5 million.
Is that a question?
Sure. Yeah.
Post-retirement medical benefit.
And
Mostly for
okay.
contract.
So that's separate from a pension. So there's pension. Okay. Okay, these benefits principally involve health care benefits, but also may include life insurance, disability, legal, and other services. So just curious, so the township is strictly health care benefits, or does it also include insurance and disability and legal and other services?
Based on the police contract.
Yeah, part of the collective bargaining agreement, whatever they're entitled to.
Okay. It said projected interest rate is 3.9%. So how does that 2.9 figure? Is that good for us or bad for us? That price lower?
Fantastic.
Okay.
Margie, it can't do better than that.
Okay.
For 20 years.
Okay. Well, but okay, then 10 years. There's a timeline for issuance. Okay. It will be a 20-year bond with a 10-year call provision. I wonder what the yield or cost to the call is. Yeah, that's what I thought it was too, but I think the S&P report does say 10. So does that need to be checked? Okay.
That's just a rating report relates to double A plus rating, which allowed the authority of the townships and thanks to the township to secure, really good rates.
Okay. And then the 17,055,000 does not include the $900,000 to pay off the Del Val loan.
$17,055,000 is the amount of principal bonds that the authority will be responsible for repaying the principal amount. Now, these concepts are complex, but the actual amount of proceeds of the bond issue, because they were issued at a premium, I believe Dan O'Brien was explaining at an authority meeting a concept of some bonds were sold at a discount, some were sold at a premium. There was a $1.5 million of premium, so the actual proceeds that the authority is going to receive on June 27th is $18,112,772 $2.25. So those proceeds will be used to pay off the 98 bond, pay costs of issuance. There's a miscellaneous amount that, in case other expenses come up, and then there'll be a $17 million deposit into the construction fund.
Okay. So, so that $900,000 that we owe Del Val, out of that $18 million proceeds, we paid Del Val that loan off for $900,000, and Del Val is no longer in the picture. We're not refunding it, right? We're not.
Well, you're refunding it and retiring. It's going away.
Okay. All right. I think that's all. Thank you.
Yes, Mr. Casey.
I have a question. It seems like we brushed over a very important piece of information here.
the addendum that you referenced. We've already passed an ordinance, and we have a pre-signed approval for this addendum. Exactly what changes were made to the original ordinance that was properly executed, and now, I mean, it seems like you said now it's going to the chairman of the sewer authority can make all decisions based on this money? I mean, or is it the chairman of the township?
The addendum to the bond purchase agreement is...
Could you please stand up at the mic?
We have 2 mics here. The addendum to the bond purchase agreement is an authority document that was signed by the chairman of the authority board. It was authorized by the resolution that the authority adopted on May 11th.
So the addendum is exactly what change was made?
The authority resolution on May 11th authorized all steps needed to approve the final sale of the bonds, which was not known at that time, by design. So the resolution authorized signing an addendum and confirming acceptance of the sale of the bonds, working together with RBC Capital Markets. So the sale happened yesterday, so the addendum was drafted, reviewed. An attachment to the addendum are the final sale numbers, and once all parties reviewed that, even the township was on that email, was circulated. The chairman or the vice chairman of the authority were delegated the authority to give the final approval to lock in the bond sale yesterday. All parties reviewed, looked at it, gave the green light, and that addendum was signed and released and made final.
So the change went from a broad sense of the authority board being able to, things would have to come back to it, to now it only goes to one person, and something was pre-authorized and signed so that the deal could be done yesterday after it was approved in a public meeting. I just feel like there's something not right with that whole process, because it should have been brought forth. This board approved something that was presented to them, and then a change was made. Meetings were canceled. Something had to be approved by the 23rd. So to do that, it seems like there was an improper procedure regarding the change. Because we went from the entire sewer authority to now only one individual, whether it be the chairman or the vice chairman of the sewer authority, to now approve all of this. It seems like there was a procedure that should have been adhered to. I mean,
I'll give you an example of how common a practice this is and how it's accepted at the state level. If the township were to issue a series of general obligation bonds of the township, for whatever reason, build a new facility, do whatever it wants, take the authority out of the picture. It's common practice to have an ordinance, in this case, of the township enacted, saying, here are the parameters within which the bonds will be sold. And let's say you're refunding bonds, you're paying off bonds. If you can achieve 3% savings on the bonds, and the chairman or the vice chairman of the board of supervisors is otherwise satisfied within the parameters that they can give the green light to the underwriter to finally sell the bonds and approve it, pursuant to an addendum to a bond purchase agreement, it moves forward. We file that paperwork with the state, they look at it, they're familiar with this common industry practice, they approve it routinely. There's nothing irregular about this process. Nothing irregular about it. The authorizations in the resolution provided for this process. It's all accounted for in how we prepared and drafted the documents, and they're reviewed by solicitors of the authority. It's an authority resolution, and there's nothing improper about it.
It's also reviewed and approved by the PCED. I mean, this is done common. This is how this process works. As long as the ultimate agreement stays within the parameters of what the authority resolves to occur, it's completely lawful, and this is ordinary accepted practice in this non-financing world.
Can I
And that
ask-
is why they hire somebody, that's the only thing he does. That is the type of law he practices. He has his malpractice insurance on the line because he guides this extremely complicated process.
Okay. At any time, did you feel like this was irregular?
No.
No.
3 times.
It's maybe common practice in the finance world, it may be common practice for the authority, but when the township board is approving and putting the weight behind it, and something is presented and then changes are made, how was this presented to the board?
No changes were made.
The ordinance, again, had parameters within which the board could offer a guarantee agreement. And none, in fact, it's gone down significantly, as Mr. Reed explained, that the 27 million was never really the intention for the board to guarantee 27 million. But until that number got fine-tuned, they had a conservative number in the ordinance authorizing the guarantee. Now that the bond sale has occurred and they know the exact number, the ordinance covers what the board did. It's not illegal, it's completely common practice, both from the authority perspective as well as the board of supervisors perspective.
But it was, something's been pre-signed, so it was
Nothing's been pre-signed. The ordinance allowed the chairman to execute documents necessary to effectuate the guarantee. And that is what occurred. That is what occurred.
Did this board pre-sign something before tonight?
It's common practice in financial transactions, when documents are drafted, approved, and you want to obtain a signature while someone's available to sign, and then you hold it, but you don't release it until it's finally reviewed and signed off by the solicitors and all the parties, then you release the signature. That's how 99% of bond closings, municipal finance, bond, bank loan closings happen. You have documents signed in advance of closing. When documents are in final form, they're shared with everyone to get the final approval to release them, and then you release the bond, you release the paperwork signed on the closing date.
Seems real regular. I mean, regular.
One other concern, this isn't new. We've mentioned that we feel like this was being rushed, What's the hurry, what's the hurry? And on June 7th, it's a critical date because MSRB, Municipal Securities Rulemaking Board, changes its municipal bond requirements. I believe if we would have waited until after June 7th, we may have saved hundreds of thousands, if not even millions of dollars.
Excuse me, ma'am.
Wait. I'm sorry, I have to interrupt you. You cannot have cross conversations between two residents. That's not the point of this meeting. I'm sorry, Doug. I'm sorry. If you want to make a comment, please come up. Okay? Sorry.
So I'll just put that out there. And then also the cost, I do get confused going between township meetings and authority meetings. But originally, I thought it was $20 million, and then we went up to this excess of, 27 it could be.
The final number.
What's your question?
Well, there's a lot of people here tonight, and
And I'm sure they'd like to get the things rolling.
Right, but West Whiteland and East Goshen is pulling out of the agreement. They are going to finance their portion of the sewer improvements on their own.
You're not pulling out
They're not financing
anything.
it on their own. They're still.
They've decided to finance it
On their own.
in a different way.
Right, so when we...
That's their choice, they have.
Right, that's fine, but, so when you took the original $20 million and you take their 30% out of that, you would think that would come down $6 million.
No sense talking about reducing the bond because it's already been. So this is a moot conversation.
All right. Another thing, part of that $17 million is also to include a $2 million reserve for the sewer authority. And I don't know why we are borrowing to make sure we have a $2 million reserve. Well, that's what was discussed, Mr. Murphy. Okay, thank you.
I'd like to comment on that June 7th. I'll back up a little bit. I mean, I'm impressed by the level of attention that citizens are paying to this transaction. These are very complicated, complex matters, and it's difficult to summarize them and present them in a concise, relatively simple way. There's an SEC rule that goes into effect June 7th, which changes how underwriters have to certify the issue price of bonds, and I can't go into explain that. It's a complicated concept, and I don't think that will do anyone any good. But they have a requirement as to, they have to sell the first price at which a substantial amount of bonds, substantial amount is defined as 10% of each maturity of bonds has to be sold. The rule is going to change to give underwriters to make sure that they comply with that rule and not handle it in a way that the SEC has thought that they shouldn't be doing it. What that changes is that how they sell and market the bonds and what they have to certify at closing. It doesn't bear on the amount of savings, the amount of it's a date in which if they would have sold the bonds after that date, there's another form of an addendum that we would have had RBC use. So we picked up on that. We said, RBC, if you sell the bonds after June 7th, make sure you have this language certifying that you sold the bonds consistent with the new issue price rule. If you sell the bonds prior to June 7th, the form of your addendum is fine. This was like 10 days ago. So the bonds were sold prior to June 7th, so it bears nothing on this transaction.
Somebody needs to make a resolution, or a motion on the resolution.
I was going to make the motion that we adopt resolution 11.
I second that.
Good. All in favor? Aye.
You have to abstain since he's on the board.
No.
You would have to have a personal financial interest in this to abstain, so absolutely not. Yep, 4-0.
4-0. Thank you.
Thank you very much. And from this point forward, we'll finalize documents and then signatures on the final lease termination agreement, guarantee agreement. Some certificates will be taken care of in advance of the June 27th closing, reviewed by our solicitors, and prepared for final
Does he
closing.
have the documents that need to be signed?
I do not. You were going to bring this?
Tonight, I just have one copy of the resolution signed.
Okay.
Okay.
We have a license agreement for separation of the shooting range.
That's correct. So under the existing lease that will be terminated as of June 27th, a new lease agreement that you just authorized through the adoption of Resolution 11, as I mentioned earlier, it was recommended that the portion of the sewer authority property that is used by the police department as a firing range, that be subject to a separate license agreement. So this document was actually prepared by the authority solicitor. I have reviewed it. I made very few edits. Mr. Lalonde and Mr. Craig also reviewed it, provided the exhibits to it. So it would allow the sewer authority to provide a license to the township to allow the police department to continue to use the portion of the property as the firing range.
But it's separate.
It's separate from the sewer lease, yes.
Right, and it does not,
Go into effect until, it will go into effect as of June 27th.
right, but it does not subdivide the property.
Yeah,
It's a
it's just-
license agreement to use that portion of the property, just to make that clear. Correct, for the use.
For their use.
And requires the township to indemnify the authority for anything that occurs within that area of the property.
I'm absolutely in favor of this. We should have done this all the time.
Yep.
I move.
Okay, next is presentation by Fair.
Need a second and a vote on it.
Yeah, vote on
We have to vote on it.
it. I just motioned.
Not the license.
Not the license, the license.
Okay.
Separation.
Yes.
So the motion is to actually approve the license agreement between the sewer authority and the township with respect to the firing range property.
Do I have a second?
I second. He made the motion, I second.
All in favor? Aye.
And then, Mr. Chairman, I just have one more thing. At the last sewer authority meeting, the authority authorized the rate study to be conducted by HRG. In that motion, Mr. Chairman, oh, he's at the line. Correct me if I'm wrong, but the motion was for the township to pay half of the sewer rate study, which the total rate study will cost $17,800. It's already been authorized by the authority, so I'm seeking approval for $8,900 to pay for one half of the rate study to commence almost immediately.
Okay, and I'll second it.
I'm sorry. I got distracted.
No, I was at the
I
last.
swear, hold on. Who made the second? Who made the
I
motion?
second.
Okay, good. Hugh and Ed. Okay.
Can we ask the sewer authority chairman to step back in here? I was at the last sewer authority meeting. I don't believe you were, sir, and
I wasn't there.
right. And I don't know that they agreed to that. I'm not absolutely positive, but I think they either tabled it.
I spoke to the authority chair this afternoon.
He's coming in now.
Phil?
Doug, you were there. Doug, do you remember?
Let's
No,
not
we
rely
don't
on
need-
Mr. Chairman. Question on the floor. Did the authority authorize, please come up. Did the authority authorize the rate study? Are you asking the township to pay half of the rate study?
At the meeting on June 11th, we, May 11th, I'm sorry. Pardon me, been driving since yesterday morning, had a 500-mile trip. I just finished 7:30 this evening. At the last meeting, a couple of weeks ago, we authorized HRG to commence a formal rate study contingent on agreement by the board to share the cost, and for the board of supervisors to determine when that would start.
Okay.
Actually,
So you did take action?
yes, we did. And that passed 5-0 by the authority 2 weeks ago.
Thank you.
Okay. I have a second.
First, second.
Order.
All in favor?
Very good. Thank you very much.
Thank you. Thanks, Mr. Murphy.
16.
Presentation by Fair Districts PA on the anti-gerrymandering initiative and draft resolution.
Thank you very much. Thank you to the supervisors and all you do to make West Goshen a great place to live, so greatly appreciate it. My name's Dean Rasmussen, and I've been a resident of West Goshen for over 30 years. I'm also a judge of elections. I've been involved in the election process for 15 years in M2. And for full disclosure, I've been a registered independent when I moved here, as Hugh knows, and I've also been a registered Republican and a registered Democrat. But I'm here on a totally nonpartisan issue tonight, and that is creation of fair legislative districts. And are you going to control the slides? Okay. Fine. And so this is a nonpartisan issue that has the growing bipartisan support. And I must say, it's not just me speaking tonight. I have brought with me petitions that have been signed by West Goshen residents, over 400 of them now, and they're still coming in, actually. And it's, as I mentioned earlier, there's I's and D's and R's on here as well. Some of them didn't indicate, but we know that that's the case. So it's a full range of that. So all the 400 residents, and myself, and the others coming in feel it's extremely important that we support what's going on in the legislature right now, and I'll get to that in just a minute. But in addition to, I think what's even more important than the number, and I don't know if 400 or 500 is an important number of petitions to have signed, or an impressive number, but what was impressive to me when I was going around and others were going around speaking with residents and going to households, over 90% of the folks, in fact over 95% of the people that we spoke to had a very good understanding of the issue and very willingly signed the petition. and it's a very brief statement on here, but they had backup material. It says, "We the people, residents of West Goshen, Pennsylvania, call upon West Goshen Township supervisors to public support and work for the enactment of legislation that will end gerrymandering and guarantee independent, fair, nonpartisan reform immediately following the 2020 census." Mr. Milan, would you like a copy of the petition? Should we hold those for later?
How long do you intend to keep collecting signatures? I'd rather have a complete.
That kind of depends on how we leave things tonight. This may be pretty much it, but we can total it up later. Go, can I have the, yes, okay. So fair districts equal fair elections. What we're looking for is to form an independent redistricting committee of citizens to redraw both the congressional and legislative districts, which we do every 10 years in this country after the census, to apply sound methodology when setting district boundaries to enable communities of interest to remain together. You might consider communities of interest commerce areas or possibly even school districts. Include meaningful opportunities for active public participation and transparency, and remove stakeholders from the politics of the process and give it to the people. So slide number 3, please. So some of you going back to your high school government class may remember the term gerrymandering, but may not have remembered how it got its name, or maybe didn't learn it. This is actually a cartoon that appeared in a Boston newspaper in 1812, and it was following redistricting, and Governor Jerry had just signed off on this legislative district, and one of the readers thought it looked like a salamander, so hence the name gerrymandering. Next slide, please. So in 1989, when President Reagan left office, he called gerrymandering the greatest single blot on the integrity of our nation's electoral system, and it's high time we did something about it. Well, several states actually have, and you can move on to the next slide if you would, please. This is unfortunately not a cartoon. This is Pennsylvania's 7th district. As I mentioned, every 10 years after following the U.S. Census, we have an opportunity to redistrict our legislative and congressional districts. And you can see back in 1952, that was a nice compact one county, and now the 7th congressional district has pieces of 5 different counties. It is only contiguous because Pocopson is right in the little joint there in the middle. Next slide, please. So Chester County, as you see here, is pieces of 3 different congressional districts, the Pennsylvania 16th, the 7th, and the 6th, which we are a part of right now. If I could look at the next slide, please. So looking at the Constitution, a piece of the Constitution, and I know all of you take an oath, as I do twice a year when I sign in for my Judge of Elections job, to follow and obey the Constitution of the Commonwealth of Pennsylvania. So Article 2, Section 16 says our legislative district shall be composed of compact, contiguous territory as nearly equal in population as practical, and that unless absolutely necessary, no county, city, incorporated town, borough, township, ward shall be divided in forming either a senatorial or representative district. So if you could go to the next slide, please. We are now in West Goshen, where we have 2 state legislators, one from the 156th and one from the 158th. Are we in 156th or 158th right now? I'm not sure. I think Hale and Pike may be the divider. So we're just, Carol Comet is here, and across the street. So across the street is Eric Rowe.
158. I'm not sure about the middle.
I think that makes my point. Next slide, please. This is our senatorial district. As you can see, well, you can't really see, but if you can draw a line somewhere around Concordville, there's Delaware County, and then there's a piece of Chester County as well. Westchester is not in there, Exton is not in there, so our school district is not in there, which isn't necessarily against the Constitution, but it's maybe against the intent of our founding fathers. So what's happening lately and why we're doing this now, although there's been growing since 1915, Pittsburgh was the first municipality, I believe, to sign a resolution. We can go to the next slide if we would, please. Thank you. Which demonstrates that several bullet points that, again, this is a nonpartisan movement. But over 35 Pennsylvania municipal boards currently have passed resolutions, including just recently and locally, Kennet Township, Ecopson, Downingtown, East Pikeland, Malvern, Swarthmore, Radnor. Last night, East Goshen had a presentation. Upper Euclid, I think earlier this month. Westchester is on the agenda, East Brandywine, and so forth. There's a growing number as well. The Pennsylvania State Association of Township Supervisors has recently voted in support of redistricting reform, and they highlight particularly support of the one person, one vote, and opposition to splitting apart municipalities. A recent online poll by Politics PA found 83% of the folks they polled in favor of redistricting reform, and our local Congressman Ryan Costello, as well as others, Brian Fitzpatrick for one, have stated publicly support of redistricting reform. Arizona and California are two of the states that have already created independent citizens commissions to redistrict, along with 4 other states, and 30 states currently, both with Democrat and Republican legislature control, and governors are currently considering fair, independent, nonpartisan redistricting reform. So let's look at the next slide, which will show us the 2 bills in the hopper right now in Harrisburg, SB 22 and HB 722, which I have, and I will leave full copies of the entire bill. But you can see the essence is to create an independent 11-member commission with individuals registered with the largest party, the next largest party, and then no party at all, unaffiliated politically in office or in relation to anyone in the household. A majority vote of 7 would be required. They have term limits, by the way. They only get to do this once every 10 years, and then they form a new commission. What I want to point out at the top there is that all of the legislators in Harrisburg are in support of this. Eric Rowe is the primary sponsor for HB 722. Carolyn Commit is a co-sponsor. Dwayne Milne, who has, I believe, Exton and Malvern and other parts of Delaware County, they are both co-sponsors. Senator Andy Dinman is a co-sponsor of SB 22. I met with Senator Killian, Chief of Staff, a couple weeks ago, along with a number of other folks. And we found out that he's in support of the essence of this, what you see on the screen. He's working on some of the technicalities of selecting the commission and filling vacancies and so forth. But he's made it one of his top 3 priorities, and we are allowed to say that for this legislative session. This does require a constitutional amendment. So what has to happen is it would have to go through both houses in this session. It would have to go through both the House and the Senate in the next session. And then it would come out as a referendum for all of us to vote on. So if I could, I would like to have the final slide. So what we're asking you to do tonight, what I'm asking you to do tonight, and what the others that are with me on paper and in person are asking you to do is consider adopting a resolution, which you will find, by the way, you should have, each of you should have a packet. And I believe the last 2 pages of the packet have a copy of a draft resolution which we're proposing. And we'd like you to thoughtfully consider that over the next few weeks. And perhaps post on your, if you would, post on publicly on your website, or if you have other ways of posting, that would be great. And then we'd like to, if can, come back and address any concerns and hope for your full approval at your June meeting. How can we help you? How can we help you to get that done, or can I address any concerns now, or any questions from anyone?
Put on the agenda for June 14th.
Excellent. Thank you.
Thank you.
Oh, and I forgot to mention, there are handouts on fair districts going around, which I believe each of the supervisors has as well, in case anyone's interested in learning more. Thank you again for your time.
For the basics concept of fair district.
I just wanted to make a comment that I was one of the folks that was out just asking people and spent 3 Sunday afternoons for 2 hours and got 75 signatures just like that. Had no idea if I was talking to Republicans or Democrats, didn't ask. I know a few that were Republican and I know a few that were Democrat, and people were very eager to sign, especially when you showed them in 1950 that Chester County looked like what we were represented. And when you look at it now and they go, you've got to be kidding me, this is just crazy. And so I think that it's something that as citizens, with Reagan years ago saying it was very important, and Obama recently saying it's very important, I think that all of us as citizens really want our voice heard and want it to be local community representation. So I hope you'll support it and let our legislators know that West Goshen is in favor of it.
Thank you. Thanks, Rob.
Thanks.
Next is FEMA floodplain ordinance, board authorization to advertise for June 14th. Okay, Rick, Kristen, you're on.
So, the federal government has revised the FEMA maps. They're called the FIRM, Federal Insurance Rate Maps. And the new maps will be effective as of September 29th, 2017. In order for residents to be eligible to obtain flood insurance, the township must adopt the latest FIRM map as part of its regulations, and it must also adopt new regulations to be in compliance with the FEMA federal regulations. In Pennsylvania, the Department of Community and Economic Development is the agency that oversees administering the FEMA regulations, and they have hired a consultant whose name is Leslie Rhodes, and she has been in communication with all the municipalities within Chester County, well, all across the Commonwealth actually, to provide a model ordinance that they are basically mandating that the township adopt. Your zoning ordinance today currently has FEMA regulations and floodplain regulations and how you regulate what properties are considered to be within the floodplain, what you can build within the floodplain, what types of measures you have to take if your property is within the floodplain. The ordinance that we've put before you is the model ordinance that the state is basically saying, if you adopt this ordinance, if you amend your existing regulations and adopt the model ordinance, you will be in compliance with the federal FEMA regulations, and therefore your residents will remain eligible for flood insurance. This ordinance is something that my assistant Kim Benzie, my associate attorney Kim Benzie, has been working on closely with Leslie Rhodes. Rick Craig has been assisting her as well. She has already sent this draft back to Ms. Rhodes because we've put in, your references to the chapter of your township code where your zoning ordinance is. We've carried over, currently in your zoning, you allow certain permitted uses and certain uses by special exception, and we've carried those over into this model ordinance, and that's acceptable to the state and to the federal government. So we're under a time frame to have this adopted, so we would like, your planning commission reviewed it last night, I believe recommended that it go forward. We'd like to send it to the county planning commission. Actually, it was sent to the county planning commission, on May 17th. We have to give it 30 days because it is an amendment to your zoning. We have to wait the full 30 days for the county planning commission to review it. So if you could authorize advertisement for your July meeting, whatever date that may be, or we could wait to hear, can actually do it at your June meeting then, if you want to wait till your June meeting to authorize advertisement, because
Well, if
you don't know what you're, yeah.
we're gonna have a hearing on Norfolk in June, then I would, since we have to update this floodplain, and it's in 30 days, why don't we do that in July?
That's fine, yeah, so what we can do is we'll bring it back, when we get the county planning commission review comments, you'll have that before you at your June meeting, and we can solidify the date of the hearing in July.
Set that date.
Yes. But happy to answer any questions. Again, we're not changing hardly any language from the model. We're just really looking at what's in your existing regulations and zoning and carrying them over into the model.
Well, the last few FEMA adjustments were insurance beneficial residents, weren't they, right? Yeah, so I mean, I think it should be. All right, then let's do that then. Is that okay?
That's fine.
We need a motion to do that?
No.
I'll just add it to the agenda for the 14th.
Next is 101 Norfolk Avenue Project, Westchester University.
So if the board recalls, Westchester University filed 2 conditional use applications, probably in 2015, I believe. We started the hearings. I think we had 2 hearings on it. 101 Norfolk Avenue was previously owned by the Alumni Association. Westchester University purchased that property and then filed a conditional use application to be able to use the existing building that's there today. And at 101 Norfolk, I believe it was an old dwelling that was converted into offices. The university filed a conditional use application to utilize that building for administrative offices. We opened the conditional use hearings and there was testimony given. They also then opened a hearing for 30 West Rosedale Avenue. The university decided to keep requesting continuances indefinitely from the township. They did not want to pursue the requested relief. They've now come back and asked that the board schedule a hearing to finish out the hearing on 101 Norfolk Avenue. The thing that got a little bit confusing was they were tying what they wanted to do at 30 West Rosedale, which was build a new 3-story, 30,000 square foot office building. They didn't have sufficient parking at 30 West Rosedale, so they were going to build a larger parking lot at 101 Norfolk Avenue. They're no longer proposing to do that. They have submitted an amended conditional use application where they're really just asking for 101 Norfolk to stand alone, to be utilized exactly as it sits today with the existing building, the existing parking lot. So they're asking you to basically, we'd have to re-advertise, but open the hearings again for them to conclude the testimony about how they'd like to use that building. And if the board's comfortable with that, we could schedule it as part of your June meeting. One of the things that I spoke to Mr. Nagel about was that I think it's important that they withdraw the application for 30 West Rosedale because they were so interconnected, and he indicated that he has recommended that to his client. He was waiting to hear back from the university, and he promised me that we would have correspondence by Monday. If by chance we don't get that, and the board is not comfortable with proceeding at the June meeting, you could open the hearing and continue it. So I would suggest that if you're comfortable, go ahead and schedule the hearing for the June meeting, and I'll go ahead and advertise it.
I would move to authorize a hearing for 101 Norfolk Ave on June 14th.
Second.
Any questions? Okay, vote, all in favor? Aye.
Aye.
Discussion and possible execution of Mayfair Circle Stormwater Pipe Replacement Project contract awarded on April the 12th.
Now, this and the next 3 are basically
Yes,
executions of what you approved at the last meeting
Yes.
for these bids. So I would move to execute all 3 in number 19, 20, and 21, since you've already approved them. I would move that you execute all 3.
Second.
Any questions? Okay. All in favor? Aye. Ayes have it. Good. We'll move it along like that. Okay, next is discussion and possible approval of resolution number 13 of 2017, Finance Department records destruction.
This is standard record destruction. Any comments, please?
No. Standard housekeeping.
Special?
Yep. All per Museum Historic Commission. We do it periodically.
Yeah.
We have finite space to store our files, and we do it by the schedules.
So we have to do it here and authorize here first. We could authorize every month if we wanted.
Sure.
to Throw them away, it's just a matter of putting together what needs to be destroyed. It's in the resolution.
I'll make the motion. I'll second the resolution.
Okay, any questions?
Who seconded them, sir?
Phil.
Phil, thank you.
No? All in favor?
Aye.
Ayes have it. And any other business to come before the board?
Mr. Chairman, I have one other.
Yes, Bob?
Bill? I'm sorry.
I just neglected during my report, there is a set of plans and a stormwater agreement.
Oh, yes.
That needs to be signed by the board. The stormwater agreement is for the parking garage at Chester County Hospital. They did not provide that to us when we did the land development. And the plans that have to be re-signed are because the owner had on the plan a different ownership name, the way they took the property than the county had. So they had to redo the plans.
So the plans were already approved, the final land development plans that the board already approved. When they went to go record them, they didn't have the correct owner's name. So they're just asking for you to re-sign the plan so that they can be properly recorded with the new owner's name.
The county record had LLC, but they are actually an LLP.
That was the change.
That was the change.
Wow.
I would move to re-sign.
I'll second that.
Thank you.
And then also, just so we have a motion authorizing the chairman to sign the stormwater management agreement for the Chester County Hospital Garage project. They need that to be recorded to be able to close out their NPDES permit.
I'll make that as a motion.
I second it, Phil.
Okay, all in favor?
Aye.
Ayes have it, good.
Mr. Schiller.
Very quickly, in the past couple of months, we had an agenda item involving a resolution for tax credit for volunteer firemen. It keeps getting tabled, but is this still under consideration?
It's on our to-do.
It's on our to-do.
I have a draft ordinance.
Yeah, we're gonna meet with both fire companies and everything to get that straightened out, absolutely. And we have to adopt by August, is that correct?
In order, well, there's no deadline.
Yeah, there's no
but you want
deadline.
the tax credit available for the 2018 year.
Right.
You need to have it adopted by August 29th, I believe.
Right. And I know all our neighboring municipalities are working on it as well, so everybody's doing it right now.
One last thing.
Yes, sir.
I'd like to ask for additional consideration of financing our bicentennial.
How are you making out with fundraising?
I'm doing pretty well, but I be honest with you, what I'd like is just whatever I can't raise that would cover it. As far as our portion goes with the joint situation with East Goshen, I think I have a good possibility of raising probably 20K.
Oh my goodness, that's excellent.
That's great.
That's excellent.
Right now, I have about 10 to 12 committed.
And we committed, what, in a budget 5?
Well, yeah, 5
It's
plus
going to
that.
say be 10 short.
Mhm.
So I think we should consider supporting it. I mean, it's in the wings, you're going to have it.
We're gonna have it.
Oh, it's going to be there.
And we have the savings, obviously, everywhere.
Yeah, the road paving community land, but.
Yeah, I think it's going to be enjoyed by all, so.
I'll make a motion.
You, I'm sorry.
I'll make the motion.
I'll second it. Comes Morgan.
Yes, Margie.
Is it possible to have the resolutions that you have listed on the agenda somehow posted to the website? So when you all discuss and move to pass a resolution, those of us in the audience don't know what you're passing.
Which one were you referring to, the paving projects and the?
Well, all of
those three?
them. All of them, I think it
They're
would be
not on the
helpful.
agenda?
They're never on the,
They're not resolutions, well,
They weren't, they weren't resolutions.
well, they're on the agenda, but are they, could you possibly put them on the website so we know beforehand?
You mean the agenda?
The copy of the proposed resolutions that you will be discussing and voting on. So a meeting package. So the agenda is on the website, but everything that you're discussing and approving is not available on the website.
Board's discretion.
Well, I just know, again, East Goshen, the borough, everybody else puts their meeting packets online.
I would rather approve them before everything gets done. What if we don't? You know? Let's think about it, okay?
Okay, and then
Let's
the
let Orange finish here.
resolution that was tabled for next month on public comment, is that going to be discussed, or are you just going to present something at next month's meeting?
No, we want to discuss, we wanted all 5 members here because there was specific input, and I think it's fair to Ms. Spinelli that all 5 of us are here. So we will be discussing it, with either approval or not approval, or modifying, amending, so it'll be.
But before a draft resolution is written, I think it would be a good idea to have the public also
Well,
involved.
that's basically a draft resolution, can be changed at any time. It can be changed and modified here.
They just saw them, tomorrow once they're presented and you have them in your hands, so. Okay,
But they
great.
can.
Thank you.
Thank you.
Doug?
How you doing?
No,
You're running.
Yeah, jogging.
I appreciate that. Make it quick.
Thank you for the car show, it was all fun. I like that car show.
You did make it.
I did make it.
I was surprised. You were at, and Ray was at.
He was directing traffic.
I was early.
You
were late.
there.
You were behind me, you followed me in, he was directing his traffic.
Come on, Doug, I really have to go to bed.
Okay. Also, as far as the supervisory packets, I prefer that not be on the website. I know Margie likes to have stuff on the website. I think that it could be available here at the building. They can come and look at it, but we should be very careful with the website.
Before we approve it.
Yes.
I know that discussion has happened year after year after year. I think a lot of part of it is informational, and I know, we're trying to get the information, and let us
Yeah.
consider.
The way you've been doing it with that and everything, that's good.
Thanks.
Anyway, and also, would it be possible to consider maybe some parking rules specifically on Warren Road? I've been talking to some residents and they're worried about cars parking on both sides of the road and
Doug, we've done Warren Road a zillion times. PD has come out, done many reports on it.
Okay, so
Here's the difficult. When you find an area in a residential community that you want to take on that particular corner and bend 5 homes and restrict the parking in front of those 5 homes, and everybody else can pay. So every visitor that they have that comes to their home, when they can only put 2 cars in their driveway, it's ticketed. They can, family, friends, they have to park 5 away. So what we do when those questions come up, we ask PD to look at it and say to us, is this a safety danger situation? And we're very, very cautious about taking away parking property rights of the person whose home we're gonna place no parking. That's why we do it. If you want, we can, Casey can again, talk to Justin, I know exactly where you are, and we can look at it. We've looked at it many, many times, and it begins a neighbor war down there.
Okay.
You can't park here, you see what I'm saying?
Yeah.
But it's tricky. You know what I mean? That's the answer to that one, I know it's long.
yeah, I just heard about it on Warren. It happens in Casmon and Cross
Oh,
Point.
it happens a lot.
So,
Everywhere you go.
Yeah, it happens a lot.
all right. Okay, thanks.
Good, Doug.
I'll move for Jim, for Lauren.
Second?
All in favor? Aye.